Good morning, everybody, and welcome to Legal and Financial Basics. This is a free community dementia education program of Alzheimer's San Diego. My name is Amy. I'm the Director of Education here at Alzheimer's San Diego. Very pleased today to be introducing you to our primary presenter of this program, Kimberly McGhee. Ms. McGhee is she'll tell you more about herself and her background as we get going. She is truly a gem here in San Diego County, a rare certified elder law attorney, and a real expert when it comes to issues of legal and financial needs of people who are affected by dementia in particular. It's an area of great expertise and personal passion for her, and we're very grateful for her time today. Free time with an attorney, invaluable. We're so grateful for that. We are also joined today by my colleague here at Alzheimer's San Diego, Mina. So I'm going to turn things over to Kimberly McGhee here in a moment. I'm just going to show you briefly what our agenda is for the program. She's going to be covering advanced care planning basics. She'll tell you what that means, what the key legal documents are, regardless of who you are and what your situation. Everybody needs some key advanced care planning documents in place, every adult. Dementia or no dementia. So she's going to be talking through what those documents are, and then talking about some needs that are specific to people who are living with dementia or caring for somebody who is living with dementia. So talking about the cost of long-term care, the benefits that folks might be eligible for, the basics of how they work, and some next steps and additional resources. Before we get going, I want to administer a very quick poll. So I'm going to launch that, and hopefully you're seeing that on screen right now. What we'd like to know, there are 3 questions in this poll. This is anonymous. We won't know what your answers are. You do have to answer all 3 of them in order to get to that submit button at the bottom. This really helps us in sort of knowing what to focus on and what not to focus on as we go along here today. If this were a normal real life classroom, we'd be able to see you and interact with you a little more readily than we can today. So we'd love to know if you are living with dementia or if you care for someone who is. Care, you can use that in its broadest context. If you care about somebody who's living with memory loss or dementia, then we're going to call you a caregiver today. Are employment considerations a concern? Often younger people who are diagnosed with dementia while they're still working have to work out questions about disability and unemployment. So is that a concern for you? Yes or no? Or are you not sure? And are you a veteran or are you caring for someone who is a veteran? So I'll give just another moment here to let those results come in. Thank you. A lot of you have responded already. We really appreciate that. It's great for us to be able to see who's in the virtual room with us here today. Okay, I'm going to go ahead and close that. We have a pretty good response. And so can everyone see those results? Are you seeing that? Okay, so lots of care partners, some professionals, and some people who are living with dementia. A few people for whom employment considerations are a current concern, and a few veterans, a few folks who are caring for a veteran, but a lot of folks who are not veterans. So thank you. Thanks for responding to that. I've closed that poll, and if it's still in your way, just X out that little box and it'll go off screen. So with that, I'm going to duck out, hand the remote control over to Kimberly McGhee, and welcome. Thank you so much for being here.
Okay, Amy, for some reason, when you sent it over to me, I lost the ability to unmute myself. So if you can send it.
Yes.
Okay.
Strange. Okay.
Okay, everybody can hear me okay?
Mm-hmm.
All right, so thank you all for being here. I wish we were in person. I feel like I do this better when we're in person, but I am going to do my best to get there to screen. What I like to do is to make it as interactive as possible. I am going to do my best to keep an eye out on the Q&A, because sometimes while I'm speaking about something, the question is more relevant at the moment. And if you have the question, somebody else may also have the question. So I can't promise I will do it, but I will try to keep my eye on that. So feel free to ask questions along the way. These are complex subject matter. It's difficult. And I highly recommend, I teach the class. I think, we have some others. I think as many times as you can hear it, the better, because these are fairly complex situations and you're caring for somebody or in the middle of your own crisis. And while we're there, it is really hard to hear everything. It's hard to understand things. I know I need multiple times. So feel free to, especially since it is live streamed, if there's a recording, take your time, look at it, review the slides, and bear with us through this remote system. Okay, so the advanced care planning basics. What we are starting with, and again, bear with me on my technology. Oh, went too far. All right, the advanced care planning. Why is it important, right? The more you plan for a situation, the better equipped you are to handle it. Let's see. While you're in a crisis is a hard time to make decisions. So if you're in an early stage, if you're in an early diagnosis, planning now is the way for you to stay in control. I always think of, when I talk about dementia and Alzheimer's, it's such a terrifying disease and such a hard disease to work with because there is so much loss of control. And as the care provider, you feel like you're out of control. As the patient, you're also out of control. And if you do some advanced care planning, you can stay in control for as long as possible. And you can help kind of control your universe. And so it's really important to put these things in place. Dementia is one of those diseases that if you put your head in the sand and wait too long, you will no longer have control. And you will be in a very difficult position. So we want to try to do some advanced planning. Basically, what kind of decisions are you going to make about what you want it to look like? You have control over this. Who is the person that is going to be in charge of things? What kind of values is it going to reflect? What kind of preferences? Are you a person that wants to be at home? Do you want to be more social? Do you have no interest in being social? In order to do that, you need the right legal documents and you need to communicate it to the person who's involved. So, okay. Advanced care planning is about planning for the what ifs that may occur across the entire lifespan. I make the joke that a good advanced plan is like a reverse jinx of your life. If you plan for it, then it won't happen. And I feel like that's an easier way to think about it. A lot of people I know don't want to think about it because they don't want it to happen. Well, you can't do that. Plan for it and hope it wouldn't happen. And that's the better. So the value, right? The value of doing this reduces the need to make critical decisions during a crisis. Think about a crisis. Think about how well you performed. Probably not well. That's none of us do. Having a plan in place is so important. For me, I've lost both my parents now. They were both fairly crisis situations, but we had a plan. And because we had a plan, I had to make decisions that I knew were correct. I don't carry any of the guilt associated with those decisions because I knew they were the right ones because we planned ahead. I have the benefit of doing this for a living, so I knew how important it was. Ensuring that the decisions reflect your personal values and preferences. That is very important. I run into situations where I get phone calls in the office from a neighbor saying that a daughter who has maybe been estranged or a sibling who has their own personal desires is making decisions opposite from what they know that this person wants. And because they didn't have a plan and they are now unconscious, somebody's making decisions for them. Their decisions are no longer applicable. And the person making the decision is, because they never wrote it down. Another big one is preserving eligibility for public benefits. The clients that hurt my soul, I guess I'll say, the ones that I carry home with me are the ones that I could have helped if they would have come sooner. If they would have seen a qualified attorney first, then when the crisis happened, I would have been able to help them access some public benefits. The goal is not for anybody to come to a lawyer and get on public benefits. The goal is to find out what's available to stretch out and extend people's assets so that they can have a quality end of life. And trying to maximize any benefit a lot of times requires pre-planning in advance. And after your loved one is gone, you or your loved one is gone, the grief is so overwhelming that if we can leave this life and make it easier on our loved ones, so they don't have to go through a probate process, so they don't have to go through court proceedings, so they don't have fighting. A good plan will allow your loved ones to grieve with the grief and not have a year and a half of court proceedings and attorney's fees and all sorts of things. So we like to try to get that plan in place. So how do we do it? We do it by estate planning. Now, estate planning is not just for rich people. I hear that all the time. Well, I don't have an estate. I don't have anything. I don't need an estate plan. That's not true. That is not true at all. If you are alive and you are over 18, you need an estate plan. And I'm going to walk through why, but it's for administration purposes, powers of attorney, for protection, so that the nosy neighbor or the interloping child can't come in and hurt you. And also so your wishes are met. And that's what's important. Benefits. Determining eligibility for public benefits, planning to prevent the depletion of assets. One of my biggest case clients are spouses that will come in and they will say, you know, we've saved, we've done everything right, but we didn't plan for this extremely expensive disease. And nobody would have had a clue. And how I always look back and say, 20 years ago, how could you have planned for this type of disease? How could you have planned for the extraordinary costs that it is? So we're going to walk through some of that. Special needs planning. So what happens if you have a child or another loved one with a developmental disability? I have a lot of clients where it's one of the children will come in, or a sibling, and we've got a person who now has some sort of Alzheimer's, dementia, but they've been caring for their adult disabled child their whole life. So we've got a 65-year-old adult disabled child and an 80 or 90-year-old with dementia. What do we do? So that's what special needs planning does. And we're going to get into a lot more details on these. And capacity, the capability or fitness to perform an action or enter into a legal agreement. It's very important that capacity is not what you think it is. and it's hard to explain because even a physician's opinion of capacity is different than the legal definition of capacity. A diagnosis alone is insufficient to deem somebody to lack capacity. That is very important. In California, you're presumed to have capacity. That means that even if you have a diagnosis of Alzheimer's, how the legal world will review you as whether you can participate in the legal planning of your life is, does your Alzheimer's impact your ability to comprehend the nature and consequences of a specific decision? So it's not a fixed issue. I've had clients that suffered from hallucinations as part of their Alzheimer's, but did that hallucination impact their ability to understand that they had bills to pay and they wanted their daughter to pay those bills? I know that it didn't. In one case in particular, the hallucination, there was one lady who really believed that her husband kept hiding under a napkin at the table. That did not impact the rest of her abilities. And it was a very interesting situation. And we worked with the physicians and we worked through the neurologists, and we were able to get this person to be able to participate in her own decision-making for a lot longer than most people would have thought. Now, if you don't do anything, then the state of California has a plan for you. And it is a conservatorship. In other states, they call them guardianships. So that might be confusing, but I never thought I'd say this, but thank God for Britney Spears, because now most people now know what a conservatorship is. It is a court proceeding wherein an individual, usually a family member, sometimes a professional, is appointed to care for an adult unable to attend to their personal needs or financial affairs. So if you do no planning and the person who needs the planning has lost the capacity to do so, meaning they cannot understand the nature and consequences of a plan, then there is a plan through the state of California. We try to avoid it. In my office, we call it the nuclear option. We do too many of them, and I wish we didn't have to, but our goal is to avoid them at all costs. So that's what the pre-planning will do. Now, how do we plan? How can we avoid this? So you need your basic documents. So if you have any assets, it's important to have a will. There is a regular last will and testament, in which most people think of as the one where I nominate my daughter to be the executor and I want my things to go X, Y, and Z, right? That's a standard will. The problem with a standard will is if you have assets over $166,250 at the end of your life, you may end up in probate. So it's important that we properly account for your assets and distribute them. And there's alternatives to things like trust, which is the next, but that's the standard. And at least what it does is you can define your wishes in it. It will most likely lead to a probate. So we really want to avoid that at all costs unless there's no other option. Okay, I have a question here. Can a conservatorship include more than one individual who's appointed to care for another? So in a conservatorship, and I think we go into more details on what they are, but yes, you can have more than one acting as the conservator. And in fact, sometimes it's a good idea, right? If we have adult disabled children, maybe it's the parent and a sibling, because then we've got different generations. We can have more than one sibling, especially if we want to share the load. So it depends on the situation, to be honest. But a lot of times more than one can work out well. Keep in mind, though, the person that you have to work with, the liability is shared. So be very careful. Don't pick somebody you don't trust. Other documents to avoid conservatorship: a trust, commonly known as a revocable living trust. I have heard more times than not, I don't have an estate for a trust. Well, you don't have to have $1 million estate to need a trust. You need a house, which in California may mean you have $1 million estate. But a house, I always tell people, the day you buy the house and the day you have children, those are the days you need a trust. And why? People get confused and they think trusts are very complex. They are written complex. When in doubt, blame a lawyer. Yes, lawyers have made them very complicated and lawsuits have made them very complicated, but they're really truly basic at their core. What they are is, I like to make a joke, it's a contract that you write with yourself. And it says, who can sign my name when I no longer can? So a good example is, how do I sell my house? Let's say I become incapacitated and I need to sell my house to pay for my care. Well, I'm incapacitated. I no longer have the capacity to sign a deed. So what can a trust do? A trust can define who can sign the deed for you when you no longer have the capacity to do it. The same thing is also when you die. What can't you do when you're dead? Obviously, you can't sign a deed. So the trust defines who can sign your name. It's really all a trust truly does. You put all your assets into the name of you as trustee. And if I no longer can act, right, I'm my own trustee of my trust. If for some reason I can no longer act because I either lose capacity or I die, I've defined who can sign my name. And then the trust includes the provisions of a will, saying, well, I want 50-50 to go to my 2 children. That's all a trust is. So people think it's very complicated. It can be really simplified when it comes to the explanation. Legal terms are complicated. But just because you don't have $1 million estate doesn't mean you don't need a trust. A lot of times there's a mistake on trusts as well, is that there are complicated ones. There's charitable remainder, there's life insurance, there's irrevocables. There's complicated ones that are used for complex estate planning. But we're talking more about the probate avoidance and the conservatorship avoidance trust. Powers of attorney. This is the one that every single person over the age of 18 needs. Now, I don't care whether you're the person with the dementia, with the diagnosis, caring for somebody, the professional, you should have a power of attorney. And why? The best reason why is because what happened when you turned 18? Nobody could speak for you, right? Nobody could talk to your doctor. Nobody could talk to your bank. The biggest fight I have with my friends' children is when they turn 18 or 19 and I yell at them and say, sign this power of attorney that your mom had me write. And they say, I don't need it. I don't have anything. And I always make the joke, you have a cell phone, don't you? And they say, yes. I said, well, if you end up in the hospital, nobody can pay your bill and you're going to lose all your contacts and your Snapchats and all that other stuff that I don't understand. And that gets them to think, oh my gosh, you're right. I do need it, because nobody could access your bank. Nobody could talk to your doctor. And everybody thinks, well, my spouse can, or my daughter can. Well, a next of kin in an emergency crisis, the hospital may talk to them. Maybe. Usually, I say in the olden days, if there was a crisis, a spouse is crying in the ICU, of course, the nurse is going to give you information. And of course, the doctor is going to ask for advice. But when COVID happened and people were not allowed into the hospital, and there was no advanced healthcare directive or durable power of attorney for healthcare, when you called to ask if my spouse was alive, they wouldn't talk to you. I got that phone call more than, I think that was the largest volume of phone calls I got during the beginnings of COVID, is that I have been married to my spouse for 60 some odd years, and I don't know if he's alive or dead. And that was happening a lot. And it's because there was no power of attorney for healthcare. HIPAA prevents medical providers from providing information to third parties. It includes your spouse. There are spouses out there who don't want their spouse to know what's going on. So because of that, you have to be careful. Durable power of attorney for asset management. The reason they're called durable, just so you know, it just means that if I become incapacitated, it's still effective. That's what that word means. When in doubt, blame a lawyer. But a power of attorney for asset management is the person that accesses your bank account, anything in your individual name, your IRAs, your 401ks, your life insurance. Anytime there's a financial or some sort of act that needs to be done in your individual capacity, that's what a power of attorney for asset management is for. So the trust and the powers of attorney, they work together, and they work while you're alive. But what happens is when you die, the powers of attorney terminate. So that's why you want your trust, because it continues on. I hope all of that made sense. Let's see. Other important documents. So a detailed advanced healthcare directive, a living will. In California, and I said it before and I'll say it again, when in doubt, blame a lawyer. We keep changing names on you. So in California, we have what's called the Advanced Healthcare Directive. That is the document in which you define your wishes. In that document is also who you nominate and appoint as your power of attorney for healthcare. So we kind of created as one document in California. It used to be called the living will. So some people still think of living will. Sometimes they confuse that with the actual last will and testament. But a living will is now your advanced healthcare directive. Just it defines what you want. And it's important because the range of medical decisions is very broad, right? One side of the spectrum is cut off my head and freeze it. I know they will find a cure for what ails me. To the absolute other side of the spectrum, when you want somebody to consider your quality of life, just not your quantity. And we don't know who you are in that, right? And people assume. I have so many spouses that when we're in a meeting and we're talking about this, the spouse had no idea, absolutely no idea that the other one felt the way they did. And that's surprising because you've got marriages for 50 years and they assume they were a pull the plug kind of person like I am, or they assume they were all treatment because we want to try to survive as long as possible. So it's important that you discuss it and you write it out. It's going to happen. So if you have your wishes written down and defined, then the person who needs to make those decisions does not have to carry a burden, right? I got a phone call at 4:28 in the morning about, your father's coding. What should we do? Well, I was woken up and out of a dead sleep. I luckily knew what to do because we had that talk. We defined it. We wrote it down. That's important. I don't want you and your loved ones to be the ones that are sitting in my office crying uncontrollably. And it takes 20 minutes to figure out that it's because you think you killed your mother, because you never knew what her wishes were. Those are the things we don't want. Don't let your loved one have to carry guilt because you don't want to make a decision. It's a hard conversation. It's not a conversation. It's what Easter's coming, I guess. I always say it's not Thanksgiving Day conversation, but you have to have it. And it's going to change. Life experiences change. My dad was always the cut off my head and freeze it. I know they'll find a cure for what ails me kind of guy. But 2 months before he died, he actually told me, I know, kiddo, you make a joke about this, but he had not been feeling well. He had a friend who had gone through a very debilitating disease himself. And he said, I don't want to live that way. I don't want to be an invalid. I don't want certain things. So it's important that you have a conversation with the person, right? If you're the decision maker, you need to find out what decisions should be made, and you should revisit it. It's not a one-time conversation because things can change in life. The waiver of Health Insurance Portability and Accountability Act. That's what I said, the HIPAA waiver. That is the document that makes it illegal for illegal is not the right word. There is a penalty for providing confidential medical information to a third party, including a spouse, child, sibling, those kind of things. So that's the document you want. Generally, your Advanced Healthcare Directive will include a HIPAA release. A lot of times it's a separate form. I know with Kaiser, I don't know if they still do it, but 3 years ago, we were able just to go up to the window, and my dad and mom both said, I have a HIPAA, put my daughter on as a HIPAA release. So it was just verbal. Pretty sure it has to be in writing now, but they put it in there, and we'll pretend he signed something. Okay, question. Is my mom's trust, which was done in Nevada, valid in California? So trusts are generally can cross state lines. We've adopted something called the Uniform Trust Act, which means we will recognize other states. Nevada and California, I am licensed in Nevada. I can tell you their laws are similar for basic revocable living trusts. Nevada is the land of trust, so they've got a lot more rules and guidelines for different, more complex trusts. But for the most part, it will cross state lines. There may be some specifics that we want to have California specific, but the majority of it remain the same. So it shouldn't be a problem. Doctor says she's incompetent due to Alzheimer's and filed in the Nevada court. Is that still okay for California? I would have to look at the trust. So the question about when a trust becomes, whether a successor trustee, which is your backup manager, the person you define who can sign your name if you can't, gets to act, the trust defines what that looks like. Most trusts say 2 letters from physicians are required so that my successor can start acting. So I don't know what your trust says, but it will be defined by the trust. And whatever it says in Nevada is also going to be valid in California. Caveat that with the banks have their own internal policies. So even if your trust says 1 letter from a doctor, a bank may require 2. So just get the 2. I always say, don't fight it. It's not worth the fight. Get the 2. Okay, if you have a power of attorney for assets and for health, and you have a will, why do you also need a trust? So the trust is important at that point. If there's power of attorney for asset and for health, then the trust is more important at death. So if there is a piece of real property and it is in the name of the decedent, the person that dies, that house cannot be sold or transferred without the person who died signature. And that is what a probate is. So if there's just a will, you have to take that will to probate, open a probate. It's about a 1.5 year process, a very expensive process. You're paying a probate referee, court costs, and an attorney gets a statutory percentage of that house, which is very high. So you want to, and it takes about, again, a 1.5 years before any proceeds are going to be distributed. So you want to make sure that there's a process in place by which all the assets will transfer without a court proceeding. And a trust is a really good way to do that. If there's no real property and it's just bank accounts and investment accounts, you can avoid a trust. Most likely, if you do beneficiary designations correctly, that has some problems with it, but there are alternatives, but you really should work it out with an attorney to make sure everything's in place, because the last thing you want to do is have to end up through a probate process while you're grieving. Okay, so there is a do not resuscitate order, the DNR. That is something that we like to put in place. If you are a pull my plug kind of person, you want to make sure this is in place. And I always talk about it with the physician's order for life-sustaining treatment, the POLST, because the POLST is that pink paper. If you are, it's supposed to be a year from death, some sort of diagnosis that they say, or if you're of a certain age and you don't want certain things, like if you are in your late 80s, you probably don't want chest compressions. The reason why is because your ribs may break, they may never heal, you'll be in pain for the rest of your life. Those kind of things can be discussed on your POLST. It's in physician's orders. So when you prepare it with your doctor, or I think it's a physician's assistant now as well. You prepare it with a medical provider and they sign it and it becomes an order. So if you do not want life-sustaining measures and they have a pink paper, when the paramedic comes, they will watch you die. And that is what's important. And if you want life-sustaining treatment, put it on there. So it's important to talk about it. And people can never remember POLST, which is fine. I always tell people the pink paper. Every medical provider knows what that is. You can make an appointment with your doctor to say, I need to talk about the pink paper. Okay, maintaining them. So you put them together, that's great, but what happens when they just sit on a shelf, right? Most people, they put these documents together, they get their pretty little binder or their folders or on their blue papers, and they stick it on a shelf and it just collects dust. And that's okay, because at least you have something. But the problem is that they're living, breathing documents. You know, you're not paying for paper. And I like to explain that to people. It's supposed to be a manual. Your estate planning documents are a manual for your life. So you're going to want to look at them. In general, the standard rule is every 5 years, you should pull it out if you're under a certain age. If you're over a certain age, and there's no magic number on that, it's really basically your life, how you feel. You want to look at it every 5 years, every year. I actually recommend people to pull it out annually because this is the good time. I ask people to take all of their end of year statements and place it in their estate planning binder or book or folder. Or envelope. And I do that. So you take out last year's and you put in this year's, and you do that so somebody can always find it. And it's a good reminder to maybe, hey, let's check it out. Let's look at things, because you want to review it, especially if there's been any major life event. This is the time when you see people rise to occasions or fall, right? You don't want to have a decision maker in there that you witnessed in a crisis do a terrible job. I like to use my brother. I hope he doesn't see this. He's a doctor. So I had him listed as my backup healthcare directive after my husband. Then when my father had a health event, I saw how he acted. The next morning, I removed him as my power of attorney for healthcare. He's a physician. He does what physicians all do. They do what the other ones say. And instead, my dad needed an advocate. I want an advocate, and that's not what he does. He's a very good doctor, but not the advocating side. So that was an example of when you want to make changes. Other births, deaths, divorces, those kind of things, any type of major new diagnosis that could be either from a grandchild, child, or yourselves. You want to look at them to make sure the right people are in place. You know, when you're picking people, I think it's important, you have to take those rose-colored glasses off. This is not the time to say, well, I wish they were like this, or I hope that they'll get their stuff together. You really need to look at it. You know, if a child comes to borrow money and they're named as your trustee or your power of attorney for asset management, that is something you want to rethink. It's not that they're a bad person by any means, but if they can't manage their own affairs, should they be managing yours in the most expensive time of your life? And I always call this time when you are suffering or your loved one is suffering through especially Alzheimer's or some sort of cognitive impairment, this is the most expensive time of your life. And so you want to make sure that the person doing it is really good at money management. Regularly check to ensure that beneficiary designations are up to date. That's very important. Laws change. Companies get taken over by other companies. Companies change software. there's people inputting things. Mistakes can happen. I have seen them happen. I have seen the paperwork that specifically says how a designation is supposed to be that was not done. So, the company even had the paperwork and they didn't do it correctly. So it's an easy thing. You can call them, you can go online, just ask for a copy of your beneficiaries, make sure they're correct. And then please let somebody know where to find the documents. We as lawyers I'm on a listserv. It's an email exchange where a lot of lawyers, San Diego probate, bars, attorneys are on there. And I can't tell you, at least once a week, there's somebody, did anybody draft estate planning documents for X? Because nobody can find them. They see a deed that's been recorded but they have no trust, right? They see the deed says the living trust, but there's no trust. So make sure somebody knows where to find them. It's very important. If they're in a safe deposit box, make sure someone knows where the key is, has access to that safe deposit box, because it won't do you any good if you die and there's a safe deposit box. Why? Because a bank won't let anybody into it without power. And you won't know who has the power until you get in the safe deposit box, which means you have to open a probate, spend a lot of money, pay $500 to drill out the safe deposit box, just to realize I didn't need to spend all that money. So please make sure somebody knows. Okay, so questions. I'm like, am I running too fast? It's always so hard to do it. Advanced care planning basics, key legal documents. So let's start with some questions. So can I use a quitclaim deed to transfer a house into a living trust? Yes. It's usually a trust transfer quitclaim deed. I highly recommend you do it with counsel, and I'm going to tell you why. Because if it's not done correctly, we either have a probate problem or we end up having to file what we call a Hegstead petition. It's after somebody passes, we can, instead of probate, we can file a petition with the court saying, oops, they were supposed to put it in the trust, but they didn't. So it's kind of like a probate avoidance option, but it's still about a 4-month process. It costs, I don't know, anywhere between $25,000 and $5,000. Depending on what county you're in California too, you may not even get it approved. My understanding from other counties is that judges don't look too kindly on them. So our judges are really good here. They get it. They understand the purpose. The law is clear and they're good about it. But if anybody objects, now you've got a litigation and $150,000 later just to get that house in there. I would have, $200 to get a lawyer to do it is a better plan. I don't know if lawyers to do it for 200, but that would be my recommendation. Okay, so I am going through some other questions.
And there was a really great question emailed to us that I would love to hear you answer.
Yes.
So this was a question that I actually get a lot and I don't always know how to answer, but it was along the lines of, I am putting the person that I care for or planning to have them live in memory care. And I keep getting different answers as to what kind of documentation I, as the care partner, need to have in place to, on behalf of my mother, make that decision for her. Some people say I need a conservatorship, which is confusing because, like you mentioned, that's such a burdensome process. Some people say I need this type of power of attorney. Some people don't even ask for it. I'm guessing it's not a black and white answer, but would you mind going into that a little bit?
It actually is a black and white answer, but the practicality is different than the law. So the law is a person cannot be placed in a secure perimeter facility without a court order, right? And a memory care is a secure perimeter facility. Any facility that has locked doors or what they call a delayed egress, meaning that you press on the bar for 15 seconds before it will open, or even wristbands. There is something about the wristbands. So if there's any type of prevention of leaving, a court order is required, which means under the law, a conservatorship of the person is required. That's the law. I will tell you, when I taught a course, we're being recorded, aren't we? But that's okay. When I taught a course to administrators of a lot of memory care facilities in San Diego, a lot. When I explained that, it was chaos. Absolute chaos erupted because they, across the board, said, 99% of our residents were signed in by a power of attorney. And I said, yes, I know. And we all know that. So under the law, only the person can sign themselves into a locked perimeter, or secure perimeter facility, or a court order is required. In practicality, 99% of the time, they're done through power of attorney for asset management. The facilities will accept it because they know that their beds will be empty if they don't accept it. In practical terms, will it be a problem? I don't know. Who's going to come after you? I don't have the answer for that. I can tell you that I told facilities that this is the law. I'm not your attorney, so I'm not going to advise you. But if I was running a facility and there was a family dispute about putting my loved one in this facility, I wouldn't do it without a court order, because they could, in theory, what is it? It's false imprisonment. It's kidnapping. It's a crime, right? Unless you agree to be placed in a locked, it's jail, if you think about it. So that's the law. And so the practicality and the law kind of work differently. So I wish, it's a black and white answer, but not really. Does that answer the question?
I think that gave a lot of insight.
Okay.
Yeah.
Let's see. So I have general advice if you agree. Title house, cars, etc. at the time of the purchase in the name of the trust. Yes, title everything in the name of the trust. That's the purpose of it. Keeping something out of your trust over here does nobody any good, because now, number one, your power of attorney has to access it. In my experience, financial institutions accept trusts much easier than they accept powers of attorney. And it's infuriating. I always say, when in doubt, blame a compliance officer. I used to be one, so I get to say that too. They make rules that protect the bank. That is what people seem to forget, is that, so if they don't like the language, right now we're fighting, we sent out 2 letters yesterday saying, this is a valid power of attorney, you have to accept it, and blah, blah, blah. They do it all the time. We never have that problem with trusts. So I tell people it's one of those ease of administration situations. I would much prefer to bring a trust to a financial institution to make it work than a power of attorney. I know recently I just had a situation with Fidelity where it didn't have a specific word in the power of attorney, so they denied it. Luckily, the person still had enough capacity to execute Fidelity's own version of it. So I always tell people, if they're going to avoid a trust and put things in their personal name, call the institutions and see if they have their own form power of attorney in addition to the power of attorney you have. I'm a boots and suspenders kind of person. I've just seen too many people be stuck when it's too late. Okay, so what's the best way to start a conservatorship process? How long does the process typically take? Okay, loaded question. The best way to start a conservatorship process is to hire an attorney. You can do it on your own. There is a conservatorship clinic at the courthouse. It generally works only with limiteds, but due to COVID, I believe they're still doing everything via email, and that's a difficult thing. Conservatorship is form driven, it's procedure driven. I am unhappy with the process. I'm actually working to change it, but it may take another 5 years. So it's a very difficult process. How long does it take? That again is a loaded question. We filed something yesterday and our number was 941. It was the 11th of January. So we read that to mean 940 other cases were filed before ours on the 11th of January. So the court system is very backed up all the time. We only have 3 judges. So it can take up to 4 months to get your initial hearing. If you have an emergency, there is a temporary option, 10 to 14 days. There is an even more expedited option, but notice is required to the person you're trying to conserve almost in every instance. So notice and getting things out to people is just time consuming. A lot of firms are pretty good at getting the paperwork drafted in a couple days, but then we're at the mercy of the court system. Again, 3 judges with they're just overworked, and the clerks do everything they can. And we are really good in San Diego compared. I can tell you in LA, there was a hearing beginning of December. We're still waiting on our order, and it's January 12th now. We still don't have it. So we are really good here in San Diego considering, but it's still frustrating because it's a very long process. So conservatorship is not something you want to wait on. Don't wait for the crisis. Okay, so the next is, this is more of a general question, but will this, well, yes, somebody may have answered that. Yes, I don't know. Somebody's going to help us and have to answer whether the webinar is going to be posted.
Everything's going to be, everything we offer is listed as a recorded webinar. So all they have to do is visit our education link, and I'll make sure to provide that link a few more times. So great question.
Okay.
Yeah.
All right. So I think that is the questions for now. And we are going to be moving on to the next, or my next question is, are we taking a little bit of a break? I can't remember.
Moving right along, I think.
Okay, perfect. Yeah. Okay. Oh, wait. All right. So at the end, I'm going to try to get back to all the rest of the open questions. I just want to make sure we get through the material, but I did block out a little extra time for people if they wanted to stay. Okay, so strategies for financing this, right? This is, again, expensive. It is going to really drain a lot of assets. It's such a hard disease to deal with, and it does require so much specific care. And a lot of times I like to explain that these facilities are just not price gouging you. The problem is that under law, right? Under the law, there are, if you need assisted living, which is, I'm declining, I still have all my cognition, but I need help, moving around, feeding myself, things like that. That level of care doesn't require as much under the law. So memory care, if you have somebody on your Form 602, which is your physician's form to get you into a facility, if they diagnose you with a dementia or cognitive impairment, under California law, that patient now requires more care than another resident. And that's why it costs so much more, is because the ratio of caregiver to resident needs to be smaller. The amount of protections just for where cleaning products are, I mean, it's very granular. Everything is such a higher level, and that's why it costs so much more. And I just want people to understand that, because it is frustrating and it's hard to absorb. So what is long-term care? Long-term care is also known as custodial care. So when you're living through it, you'll hear custodial, oh, we don't have any custodial beds, that kind of thing. That just means long-term, not rehab or short-term beds. And it's going to be care that refers to services and support and care settings that are non-medical assistance. And it's with activities of daily living. You're going to hear ADLs a lot through this process of dementia and Alzheimer's. And activities of daily living are bathing, dressing, toileting, transferring, like moving from bed to couch, couch to toilet, that kind of thing. Feeding is actually hand to mouth, not cooking. Recently, medicine maintenance has been added to it, but I don't think it's on Medi-Cal's list still. But those are what you are going to be thinking about. And so when you talk about ADLs, those are the basics. And so you've got community-based, and bear with me on some of these language, but community-based is like a term of art. It's anything outside of an institution. And so there's in-home care, right? We want to keep people in the community, in their home. The best ways to do that is, I can't care for my loved one 24 hours a day, but if I can find an adult day program, that's going to offset some of these extraordinary costs. There's also the PACE program. Here in San Diego County, we are blessed with it. Not all counties have it, but it is an option through Medi-Cal where it's like a continuum and like a multi-group of care products, I like to say. You've got transportation, you've got day programs, you've got just a worker who will help manage all of their doctor's appointments. There's support that helps people stay in the community, so you don't have to be institutionalized. Then you can residential care, which would be like boarding cares. You'll hear them called six packs. They're private homes converted into a residential care facility. So it can be in any community, and there are some homeowners associations trying to get rid of them, but you can't. There's an exception. And it basically allows for people to live in a home-like setting, spread out the cost of care. I used to make a joke with my parents because they didn't have the ability to pay for long-term care, that if they needed it, I was going to turn their house into a boarding care and they just get roommates. There was it's a way to, some people like the home-like environment. Other people don't want a home-like environment and they like the condo living. And so I call it that's assisted living. I like to call them cruise ships on land. There's actually two different kinds. There's cruise ships on land, and then there's dormitories. And if you understand the difference, they can be what you want. One's not like the other. You need to go investigate. You need to look at them. Assisted living is going to be anything that's not memory care and not skilled nursing. So memory care, we kind of just walk through, that's an assisted living facility that has secure perimeters. It has some sort of prevention from leaving. So memory care is going to be where your people with cognitive disabilities live. I have clients where their spouse and the person with cognitive impairment will move into a memory care facility. Some facilities are much more open to that than others. Some will give the secret password to get in and out to the well spouse. It just depends, which is where you kind of have to go look. And then there's skilled nursing, which is long-term care, which is also known as rehab. So most skilled nursing facilities are the old convalescent homes that we think of. They will most likely tell you they are only rehab facilities, but they're not. Most of them have custodial care. They just don't like to advertise about it. So next, what did I do wrong? Let me try that again. Oh, here we go. Paying for long-term. I just need to make sure. Yeah, I hit it too many times. Sorry. Let's see. The cost. So I guess I forgot the cost part. Okay, community-based. This is usually the most expensive, right? Any time of in-home care, that is, now we have a minimum wage of $15 an hour. So right there explains a lot of the cost. They're not minimum wage employees, or they are, but if you go through a company, now they need to get their cut. So they're like $30 an hour at this point. I've been getting quotes. So I think people are telling me $35 an hour. So that's where the adult day programs will help, because that is, a lot. I don't have to pay for care the whole time just for that price. Boarding cares, assisted living, and memory care are all going to range. They can be $2,500 at certain boarding cares, all the way up to, I think there's one that's $9,800 in a memory care. Skilled nursing, the average private pay rate is, we're looking over about $11,000 right now, and that's for all of California. So most here in San Diego are about $12,000 a month. So how do we pay for it? Personal savings and assets, right? That's what most people use. If you were lucky enough to have bought long-term care insurance, that is the one thing you are to not stop paying. I know it seems expensive, but it's hard to get it these days. A lot of people have told me that it's just better to put the money away and invest it than to pay for some of the new long-term care insurance policies out there. What happened is people are living a lot longer than the actuaries thought they would when they sold these in the 80s, 90s, and early 2000s. So because of that, it's not financially feasible for them a lot of times. But if you have it, oh my gosh, thank goodness you do, because we are going to be able to supplement your care for a much longer period of time. A lot of time people use things like their home, right? In San Diego, our largest assets are usually our homes. So when we're talking about reverse mortgages, be very careful with them. There are some that are good products, and there's a lot more that are not good products. I have been blown away by finding some that have these 2% and 3% interest rates that people have had for a long time, and it works, and it's a great product. Then there's other ones who took $90,000 out of a reverse mortgage and in 10 years owed $500,000 for that 90,000. That was a terrible product. So you want to be very mindful when you're talking about it, because a reverse mortgage, I highly recommend, if you're going to think about it, do not get a lump sum. A lump sum will not help you at all, because you're going to spend it, and you're going to spend it on other things. I prefer people to get some sort of line of credit and just pull out what you need at the time. Because if your home is your largest asset, you don't want to use up all the equity in that home when you're going to need the equity to pay for care in a facility. And so the goal would be to, how do we maximize it all at the same time, while also maximizing our equity for later. There's also things like charitable gift annuities. So if you have, let's say you had an investment property that if you went to sell it, you would incur a substantial amount of capital gains, and you would lose maybe half the value of it to taxes. There are things called charitable gift annuities where you can basically donate it during your life to a charitable organization, and they will pay you a monthly fee. You won't pay any taxes. So you'll basically get the maximum value for that asset while being charitably inclined. So you can really help two things at one time. So that's a good thing. Converted life insurance. Please, if you have a life insurance, don't stop paying. If you can't afford it anymore, there are, number one, there's policy and there's new legislation. It's not new, it's like 5 years old. But there is legislation out there that allows for somebody else to purchase that life insurance policy and put it into a long-term care type asset for you. So it's a really good thing. It works out great for some people. I've had people sell term life insurance policies that I did not think have any value, and they got like 30 grand for it. And I think 30,000 is better, and they didn't have to keep paying on something. So if you couldn't afford to keep paying, it was a great option. Most people, when they start talking about paying for their long-term care, are going to be looking at their Medi-Cal and their VA options. So just so you know, for definition purposes, in California, we call Medicaid Medi-Cal. Medicaid is the federal name for the supplemental insurance and long-term care that is not Medicare. So there's Medicare, there's Medicaid, and then California calls their Medicaid Medi-Cal, just to be confusing. But we're California, we do what we want. And then you've got your VA benefits. And so we're going to go into those. And it's important that Medicare does not pay for this. It's very important. Medicare will pay for up to 100 days in a skilled nursing facility after a 3-day hospital stay. They will pay for 1 to 20 days at 100%, and then 21 to 100 days at 80%. And your supplemental care is going to have to pay, your supplemental insurance will have to pay the difference. It's usually a very high copay. My experience, Medicare does not pay for that full 100 days. You'll get a notice on day 14 saying that your Medicare is not going to be covering you any longer. And then you have to fight it, find a place to go. It's very important when you hit this crisis that you start looking at how to maximize all of your assets. And so how do we maximize the cost of care with our taxes? And this is something where you have to consult a tax professional. I tell all my clients, I know that you're capable of preparing your own taxes, but this is the time to spend the $500 to get the tax return done. You need to work with a tax professional, at least at the beginning, to come up with a plan. How can you maximize your assets, right? Let's say you have an IRA, 401k, pre-tax dollars. This may be the time to start pulling from there. Even though every dollar you pull out of there is taxable income, is it going to be offset with in-home care services, with residential care services, with other non-covered medical expenses? What type of tax deductions can we maximize? How can we use our assets correctly? And that is one of those things we always want to look at. Now, I do know that a few of you have employment considerations that we need to work with. It's important that if you are in a position where you are still employed and you have a diagnosis, do not just hide it and get fired because of a cognitive impairment. It is a disability and we have protections there. There are some companies that you didn't even know may have a long-term care benefit if you are employed by them and get a diagnosis of Alzheimer's. I've actually seen it happen when somebody didn't know they had it. So it's important. I recommend talking with an employment lawyer just to kind of walk through how to do it. If I don't know if we have any on this list, if not, you can call my office and I'll give you a couple names to call. A lot of times just disclosure, saying that I have this disease. It doesn't impact my ability to X, Y, and Z, but I need accommodations for A, B, and C. Those are the kind of things that you need to want. So you need to disclose it before you get fired. Because once you're fired, whatever benefits were out there are gone. So there might be an employee assistance program. They might have short-term disability benefits at the company. And I said long-term disability. I was really amazed. The Family Medical Leave Act. So at this point, if you're the care provider, this is something you want to look into. It's important to look for it. We have a lot of emergency things going on with COVID. So there's even more that's there. So I want you to explore it. Don't lose your job because your loved one got sick. And then also early retirement. I mean, you might be able to retire with some sort of benefits, especially, added on medical, things like that. So it's important to really look at the options. Don't just put your head in the sand because that is not a solution. Compassionate allowances. So if you are currently employed under 62 and you need to go on to disability, so your Social Security that you've been paying into, right? That's your SSDI. You're going to be able to pull that out. And if you have a diagnosis of Alzheimer's, there's also Parkinson's. There's a few that are on the list. If you fit the list, then under the compassionate allowances, it expedites the process of your SSDI claim. Right. And the important part of that is because sometimes it can be 6, 10, 12 months before you see anything, and you really need to get this moving. So you want to always, when you apply, explain the diagnosis and why, so you can kind of get put to the top of the list. Okay, so dementia diagnosis is on the list. Here is the list. I forgot we had a slide for it. So the young onset, the FTD. Now, for those of you who don't really are working with it, trying to figure out, you're here, so you probably know, but I've seen a lot of people not recognize the frontotemporal dementia early on. And I always kind of tell people, when somebody's decision-making skills were used to be good and then stopped being good, this is where you want to check on it. The primary progressive aphasia, I've seen that with people and how the compassionate allowance really made a big difference. And then the other mixed dementias. So it's important to look at that. Okay, I saw on our poll, we've got a few people with veterans issues. So maximize the veterans, right? If you were the veteran, thank you for your service. You earned additional benefits. If you are a spouse of a veteran, you also, having to put up with your spouse, earned some benefits. And so if you're a care provider for somebody who was a service member, maximize these things, right? Maximize, get them through the health insurance, get them on that. I know we heard horror stories of the VA system. San Diego has always been better than everywhere else when it came to the VA. And I hear phenomenal stories. Yes, there are still bad. I mean, let's say government's not really good at running things. But there are some really good benefits. Number one is additional medical insurance, getting rid of certain copays, getting cheaper drugs, hearing aids. I'd love to save $6,000. All of those things are covered. So you're going to want to maybe try to get a better, I see some of the copays that some of my clients are paying, and I think, man, I sure could use an extra $300 a month. And if just running through the VA benefit health insurance gets you $300 more a month because you're not having to pay exorbitant copays for medical and other prescriptions, do it. What's it going to hurt? It doesn't mean you can't still see your doctor. It's just an additional insurance. Medical care, again, I've seen some of the best work done at the VA hospitals. I have some friends who are VA doctors, and I'm always impressed. They had better experiences, and they're not fighting with health insurance as much anymore. So it's kind of interesting how there was a shift that in a lot of our hospitals we're feeling, and I don't know if you've done that, but if you're feeling this, you're feeling rushed and pushed out of a hospital, it's probably because the billing department is worried they're not going to get paid. That's not really what's happening at the VA hospitals anymore. So, because they don't have that same insurance policy problem. So it could be a benefit. There's also service-connected disability income. So that means is if you were during service, not while you were in combat, but during your service, right? Service is 24 hours a day, 7 days a week, 365 days a year. You're on active duty. They do not let you just go take vacations, right? They frown on that. They call that AWOL. So because of that, if you were on active duty, you were injured, that's a service-connected disability. You don't have to get shot. And I'm going to say that again because it's important. If you twisted a knee playing basketball while on active duty and you got treated for it, then you're going to be able to claim some sort of service-connected disability. As when you were 18, 19, 20, it didn't bother you. As now, though, you can't walk on that knee. That might entitle you to some benefit. So please look back, think back, talk to your loved one, find out if there's any injury that may have happened during service, because there may be some financial benefit for it. Pension benefits. There is what people think, the traditional that people think of pension, like I serve my time and I get money, $400 a month, whatever it is for my service. Non-service connected, though, this is what people call aid in attendance. So if you've heard of aid in attendance, this is generally what they're talking about. There is another aid in attendance, so it's kind of a bad name to use it, but non-service connected pension benefit with aid in attendance is the benefit that people talk about when you can get reimbursed for medical expenses. And the VA defines medical expenses to include caregiving services. It's the only program that does. So if you are financially eligible, so if you're service eligible, meaning you served 1 day during an active wartime period, those periods are longer than most people think, you served for 90 days total, and you were more than dishonorably discharged. So there's multiple ways to be discharged. So medical, honorably, things like that. Then you would be eligible. Now you just need to be financially eligible, meaning that your net worth can't be more than, I think it's 130. It just went up. And I can't remember. Do I have it sitting here? Oh, I magically have my notes. Oh, no, that's Medicare. Let's see. I think it's about 130,700 something. That is your net worth. So it's your annual income plus your assets. Assets don't include a house, don't include a car. So you may be more eligible than you're not. If somebody is thinking about needing long-term care, selling their home to pay for it, before you do, and you are service eligible for VA benefits, please, 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 please see a qualified elder law attorney. There is still a process that we can do to maximize those benefits while also selling your house and not disqualifying you from being eligible. It's very, very important that you see somebody, because once you've done it, it's too late. There's also a death pension. So if you're the surviving spouse or a surviving disabled child, you may be also entitled to a dependent and indemnity compensation. There may be also some assistance with burial support and things like that. And then the VA caregiver support program, oh my gosh, I have had clients have miracles done for them, only because, as a caregiver, you do know how hard it is and how exhausting it is. And just to have some support, there can be programs and options that are available that I don't know about at the time, that other people don't know. But it's when you happen to get support and they talk about, oh, we've been funded for X, Y, and Z for this year, and then you happen to get in it. It's so important, and you should reach out for help. So the VA caregiver support program, adult day health care. Oh my gosh, I had a client, she was qualified, she paid $20 a day. That was her out of pocket for the day program. She was eligible for it at the time. A spot opened up. It was great. Home-based primary care, you can get some in-home programs, homemaker, home health aid, those kind of things. Telehealth, being, that became, we all kind of do that now more thanks to COVID. But it's important that, if I can't get to the doctor, but I still need a doctor. Respite. Oh, if you don't know what respite is, it's because you need it. That's the answer I always say. Respite is, support. It's temporary placement. It's taking a break. It is a weekend, right? I've had clients say, I can't place my loved one. They need to stay at home. And I said, yeah, but you're getting get sick if you don't take a break. So, like a vacation there, as I said, there's some cruise ships on land. Some of these assisted living places are cruise ships on land. Put them on a cruise. You go take a break, put them on a cruise ship on land for a couple days so you can get some rest and you can rehabilitate yourself. Skilled care, you can get either in home or there is a skilled nursing facility down in Chula Vista. Barstow is an option for memory. People think, oh, I don't want to go all the way there, but it's a nice place. So sometimes if it's the only option, it's not a bad one. And there's also home hospice care too. Okay, so Medicare. Medicare, again, I don't want anybody to be confused. Medicare, Medicaid, Medi-Cal. Medicare is the insurance, right? It is the federal health insurance program, and it's paid out of your Social Security deductions. If you worked or your spouse worked, you paid into Social Security, you become eligible for Medicare. It is not based on your financial need. Bill Gates gets Medicare when he retires, when he reaches the age. So how it works for Medicare, though, is you've got all the parts. People get confused. So your Part A and Part B are what comes with everybody's. It's your hospital insurance. Part A also is your skilled nursing. So when you're looking at in the long-term care setting, Medicare Part A matters. You want to get a good one. If you've got the opportunity to switch around your Medicare, don't just think, how do I save, be the cheapest? You want to make sure that you also qualify for a good skilled nursing facility. So Part A is your hospital and skilled nursing. Part B is just your basic medical insurance. That is your doctor visits and your prescription, portions of your prescription pickups. Your Part C is a Medicare approved private health insurance. So those are kind of like when you think of more advantage plans and things like that. Part D is your prescription drug coverage. It's your donut hole, the gap between the insurance, what the insurance will pay, and your prescriptions. And then you've got the parts F, G, and N. Those are supplements, so the Medigap. So if you have a specific need, you want additional things, you can buy the extra programs. Medicare does not cover the cost of long-term care. I'm going to keep saying that because people keep thinking it does. It, again, will pay for 1 to 100 days, 1 to 20 days at 100%, 21 to 100 days at 80%, and your supplemental is going to pay the difference at a very high copay, probably $150, $185 a month or a day. It's very high. So, but again, I see it all the time. Medicare kicks you off of that. So your Part A is what governs that. So there are some Part A's that are better at coverage than others. I can tell you the VA, if you've got some sort of TRICARE for life, those kind of things, you're going to get your longest amount of time there. So those are the ones I see it. So that's why working with the VA, if you can, only benefits you. It's not going to hurt you. So let's see if Medicaid and overview. All right, as I said, Medicare, Medicaid equals Medi-Cal in California. I think Massachusetts also does it. There's this called like MedMass. But Medi-Cal is California's version of Medicaid. So it is a federal and state program. It's funded through state as well as through federal funds. Mostly federal at this point when you're looking at some of these programs. But what it does is it provides free or low cost health coverage for children and adults with limited income and resources. So that is the medical insurance side of Medi-Cal. It will pay for medically necessary healthcare services. But what in our context that most people think of why we need it in the Alzheimer's world is it will help pay for long-term care. So our long-term care program is unique. There are some states that have better options, but we do things different. So it really, the point is to provide protections for the middle class. It was truly for spousal protection. It was the idea of what do we do when one spouse spends all the money on care and the other spouse becomes homeless because of it. And that is what I like people to think about why we utilize it. It has such a benefit to protect for spouses. Some people want to protect legacies, and we do Medi-Cal planning for that. But for the most part, we also think about it as in spousal protection. So we're going to get into some real details. Okay, so who's eligible off the bat? So if somebody is receiving SSI, which is the supplemental security income, that is, I don't have a work history, so I'm not entitled to Social Security disability income, or my work history is so small that I don't get up to the $947, I think, a month that it pays out, then SSI will kick in some money. If you are qualified for SSI, you're automatically into Medi-Cal, so you don't have to do anything. It's also for individuals whose income makes them ineligible for public benefits, may also qualify for medically needy. So let's say I have more money than what the Medi-Cal list is, but I don't have enough money to pay for the services I need. Medi-Cal will support that as well. What happens with Medi-Cal is there's some kind of buzzwords. So share of cost with Medi-Cal. I like to compare that to your copay. Think about your share of cost as your copay. If you have income over $1,647 as a single person and 18 something as a married couple, you can still be qualified for Medi-Cal, but you'll have a copay. You'll have a share of cost. And so it's just a math problem. They figure out what you would do. When we talk about Medi-Cal, there is financial eligibility in it. And so spending down is a buzzword you're going to hear, and I'm going to talk about that. And then there's also estate recovery. People get very nervous when they talk about Medi-Cal, because when you are eligible for Medi-Cal and you start receiving it, you get a letter, a flyer that says estate recovery. Anything that Medi-Cal pays for you, they're entitled to get back after you die. Yes, that's true, but with limitations now. So the changes that were implemented means that only your probate estate is available to be recovered against. So when we were talking at the beginning about the importance of trusts, because what a trust will do is it passes everything without a probate, right? Somebody signs your name and distributes it without the need for a judge to do it. That means that Medi-Cal cannot collect anything from that trust either. So if you have to go to probate, Medi-Cal gets notice of that probate, and then they can make a claim against it. They will only make a claim for services over the age of 55 in a skilled nursing facility or other community-based programs. And if you have a spouse that is living when the Medi-Cal recipient dies, they cannot recover either. So those were the changes. So it's more of a limited, which is why planning matters. I'm going to always bring it back to the importance of planning. If we planned properly, then we can get you eligible, and we can also prevent recovery. So it's very, very important. So Medi-Cal in long-term settings. So my favorite thing that I like to use Medi-Cal for is in-home supportive services. In-home supportive services is private caregiving in your home. Medi-Cal will pay for up to 268 hours, 86. Sorry, I don't have the numbers memorized off the top of my head right now, but approximately 286 hours a month at minimum wage in the county you're in, which for us is $15 an hour. And that is what they will pay. So if you're eligible for Medi-Cal, then you can also apply for in-home supportive services. That is just a social worker comes out to you. And well, with COVID, it's mostly remote, but that social worker will then determine how many hours you need. And if somebody needs 24-hour care, they're going to get the maximum hours. If you can utilize in-home supportive services with private funds and all sorts of, these programs, you can stay at home and out of a facility. And how wonderful is that? Community-based adult services. These are going to be other programs that are out there. So at the, here in North County, we have the Mary and Gary West PACE program. And there is, you've got the transportation, you've got food, you've got day programs, you've got medical services, you have all of the continuum of all the services that are needed. And Medi-Cal covers it. It's been fantastic. Medi-Cal covers skilled nursing facilities. Not every skilled nursing facility accepts Medi-Cal. So that is very important. If you are in a hospital, and if you take nothing away from today, but what I say right now, this is what you should be listening to. So pay attention right now, everybody. If you or your loved one end up in a hospital 3 days, you are then going to be discharged to a skilled nursing facility, right? The hospital is going to try to push you out as fast as possible, even without a diagnosis. You have a right to a diagnosis, number one. But if you are going to be discharged, a social worker, and I'm going to put that in quotes because it's not these social workers, it is a hospital discharge planner, is going to come and say, here's a list of facilities that have beds. You want to cross-check those beds, those facilities, with ones that take Medi-Cal. There are some fantastic skilled nursing facilities, and by fantastic, I mean it's still a skilled nursing facility. But for a skilled nursing facility, there are some of the best that do take Medi-Cal. And so, but they're not going to advertise it. You want to make sure that you pick a facility if you're going to need long-term services there and you cannot afford $12,000 a month. You are going to make sure that you pick one that accepts Medi-Cal. Okay, so 3-day hospital stay, make sure before you move, you find out if that facility accepts Medi-Cal. The facilities are going to hate me for this, but I always say just call anonymously and ask, because if they find out you're going and you're looking at Medi-Cal, that bed might be gone, by the way. So that's not legal, but they are going to say there's no room at the end. And then there's also the assisted living waiver program. That would be for assisted living facilities. Not all facilities are there. There's a long wait list. It needs to be properly funded. So it's not something that we can count on. Not all counties even do it, but it is an option and it works for some people. Let me try. I didn't move it. Sorry, I'm not very technologically savvy. And I don't know why my page is not flipping. Let me try again. Okay, did I go too far? I think this is the next slide. So Medi-Cal eligibility. So this is not an exhaustive list, but in order to be qualified for Medi-Cal, and I'm going to be talking in 2 different time frames. Let's see, I don't want to overwhelm you with too much, but in August of last year, the state of California legislature changed the eligibility requirements for Medi-Cal. And they made it so that as of July 1st of 2022, so this year, the property you can have is $130,000 in assets as the applicant. Okay. And right now, though, it's $2,000. So the law was changed. It becomes, in order to become effective, the federal government had to approve it. And they approved our change in the law, California's change in the law, right after Thanksgiving on November 24th or so, which means that currently, if you want to get on Medi-Cal, the applicant, the person who needs it, can't have more than $2,000 in their name in cash and liquid assets and stocks, bonds, things like that. July 1st of 2022, they can have $130,000. So there's going to be a change. The federal government approved that. Part of the law that California changed is we also changed it that in 2024, there will be no asset limitations. That has yet to be approved by the federal government. So I do not know what they're going to do. I have heard rumors that it will be approved by the end of this year, but that is a rumor. So don't count on a rumor. But so I'm going to kind of talk about, I don't know the exact number you can qualify depending on when you need to. It's either 2,000 as the applicant or 130,000. And I'm going to get through what happens if you're married in the next slides. But you can also, in addition to that asset, the 2,000 or the 130, you can have a home, your principal residence. You cannot have a home and a rental. The rental property now becomes an asset calculated in that 130 or 2,000. You can have household goods and personal effects. Nobody has jewelry anymore. We all have heirlooms. Okay, that's important. You can have a vehicle, one vehicle per household. If you have two, then the value of the cheaper one counts as part of that 130,000 or 2,000. You can have term life insurance. The difference between term and a universal or a whole is there's no cash value. So that's why you can have a term life insurance. You can have a burial plot or prepaid burial plans. You can have IRAs and other work-related pensions that have a cash value as long as it was pre-tax dollars and it's in payout status. So if you're over 72 and a half, it's in payout status because you're collecting those RMDs, that required minimum distribution every year. So spousal protections. They're, as I said, that, Medicaid, our Medi-Cal, was really created to protect the spouse. So there's a community spouse resource allowance. So as we talked about, the applicant, the sick spouse, can have $2,000 or after July 1st, $130,000. But if they're married, the well spouse can have $137,400 in addition to what the sick spouse can have. So that's, it can be stocks, bonds, cash. So if you've got an IRA and you've got a residence and you have $80,000 in the bank, you are qualified for Medicare. So I think the best example I ever gave, and it kind of mind boggles some people, was a client came in, husband had fairly young diagnosis. They had a house in Del Mar worth about $2.5 million. They had about $1.5 million in their IRA, and she had $83,000 in the bank. And she didn't know what to do. And I said, we were qualified for Medi-Cal. And it was just mind boggling to her. That is the law. So your home of any value currently, plus she had the community spouse resource allowance of $137,000. At that time, I think it was like 130, but because it's that amount increases every year. So that's your assets. But Medi-Cal, as I said, is based on income too, right? There's that minimum amount you can have. So Medi-Cal, if you're married, rather than just if only one spouse needs it, and there's a well spouse at home, the well spouse, instead of just having that $1,640 or $1,800 a month, can now have a minimum monthly maintenance needs allowance. You'll hear it called the MIMNA of $3,435. So the example would be something like we have, and I'm going to try to use easy numbers for me. You've got a husband who has $2,000 in income of Social Security. Wife has $1,000 in income and Social Security. Together, it's only $3,000. So since the wife's minimum monthly maintenance needs allowance is determined to be $3,435, the wife gets to keep 100% of the income, all $3,000, and then the share of cost is zero, so that there's no amount that would be having to come out of pocket for Medi-Cal. If, let's say, the husband is the sick spouse again, and he has $3,000 a month in income, and the wife has $2,000 in income, and husband needs to go on Medi-Cal, then because the wife only has $2,000, she gets to steal $1,435 from the husband's $3,000 a month. And I can't do the math, but the difference is what the copay would be to Medi-Cal. I hope that made sense. So the idea is, how do we protect the spouse? And that's the goal. So benefits of planning, we're going to kind of come full circle here. If we planned for this in advance, if we talked about it in advance, we can avoid spending down. So what exactly is spending down? If I have more assets than the 2,000 or 130,000. I'm going to go back. The community spouse resource allowance, when the $130,000 number in July 1st becomes the new asset amount, you add the 137,000 to it. So the combined total the couple can have is 267,400. That's a substantial amount of assets you can have in your name. But what if you had 300,000? So that's your 36,000 over. Again, lawyer shouldn't be doing math, but $36,000 over, you have to spend that down in order to qualify. And spending it down would be paying off things, paying down mortgages, paying off the car, things like that. And that's hard because sometimes we need the assets. We don't want to spend it down. So if we kind of planned in advance, we could do things like asset protection. Elder law attorneys, just like if you're going to look at VA benefits and you own a home, you need to talk to an attorney. There's also Medi-Cal planning that we can do that's very similar. They're not the same because the penalties are different for moving assets around, but an elder law attorney can kind of walk you through how can we preserve some assets and still qualify for benefits. So if let's say there's $700,000 in assets or $500,000, that's too much, right? You have too much. But for Medi-Cal purposes, they allow a certain amount of stacked gifting, and it's a way to transfer assets out. It's approved by Medi-Cal. You disclose it to Medi-Cal. It's acceptable procedure, but you have to do it in conjunction with somebody qualified to do it. So planning gives you that option. You want to protect eligibility. So if you just gave away $100,000 to somebody and tried to qualify for Medi-Cal, you'd be disqualified from Medi-Cal for 11 months. You can't just transfer money around. So you need to make sure you're doing it properly. You also want to maximize the benefits, right? If we're planning and we work at how do we get this while maximizing that, while spending that, it's important that we kind of look at the whole picture. There isn't a magic bullet for everybody. Everybody's different. It's a plan per person. So there's no magic book to look in, unfortunately. I wish I could give that to you, but everybody is so unique and the situation is so unique. You'll need to kind of work that out. Protections for the community spouse. I just can't tell you. You didn't spend 60 years together just so one person can be homeless. So we got to do that. And we also want to minimize the share of cost. There's some planning that can be done just by buying some extra insurance, gets you qualified for Medi-Cal. It's a silly thing, but it's the law, so we do it. So, and that's a lot that I just kind of gave at you. So now I'm going to go through all the questions, and we have plenty of time to go for a very long time with questions. So
yeah, just a heads up, Kim, we have until 11:48 for this round of questions. So whatever questions you feel like would be great to answer. We have some time until then.
Okay. All right. So when we were talking before about placement in a memory care, one of the questions that came up is, can the memory care issue be addressed through the Advanced Healthcare Directive or PULS? No. So somebody cannot preemptively say, I agree to I agree to allow you to lock me against my will. That doesn't you can't do that. What you can put in there is that if I have a memory care issue, cognitive impairment, and my doctor believes I can use memory care or secure perimeter facility, you can put in your document that is your choice, because under the law, it's a presumption that you want to stay at home, and that it's a presumption that it's the less restrictive alternative. So you can kind of overcome that burden and make it easier to get a court order. But if you object to it at the time, or your loved one objects to it at the time, you've got an entire trial about it. So let's see. Can an irrevocable special needs trust ever be changed? Under what circumstances? So all irrevocable trusts can be changed through either a court order or something we call decanting. Decanting, you think of as wine, right? You pour it out and let it breathe. It's the same thing in theory. You take your irrevocable trust and you pour it into another one. decanting requires, there are certain requirements to have a mirroring language, so it might not work, but the only way to truly change an irrevocable trust is through some sort of court order. If an Alzheimer's patient refuses to go into memory care and it's not safe at home, then what type criteria make them eligible to get a conservatorship? I'm told by several social workers that my dad is too believable and will be denied by a judge. Okay, that is a big problem. Alzheimer's patients who present very well are probably the hardest ones to deal with. But the reality is if the neurologist agrees, I mean, you may have a full trial. You may have a $150,000 legal bill at the end of it, because everybody has a right to be kept in the community. If dad objects to a conservatorship and a placement, then you now have to prove that it's not the least restrictive alternative. He is a danger to himself. He does need to be placed. And so the medical evidence is really going to be the only thing that wins in that case, but you're going to have to go through a full trial. So sometimes I tell people the expense may not be it, and it's a very hard situation that you're in. My investments are with Fidelity. The missing word alerted to me. So it just happened to be in this case that the power of attorney did not allow the agent to act without limitation. So it was specific. A lot of powers of attorney will say for IRAs, can they act for special things? Is there limitations? Are there not? And in this one, it didn't have a without limitation. So what I do is just send it to Fidelity, see if they'll accept it. It's very simple. Okay, if you live in a community property state and you have a will and a power of attorney for assets and for healthcare, then is the trust unnecessary for the spouse? No, it's very necessary. So if the asset is held only in the name of one spouse, even though it legally under community property law, 50% of it may belong to the other spouse, you still will have to go get a court order. It's called a spousal property petition. So you're still going to court, you're still noticing, stepkids and all sorts of people that may want an interest. We've got a case right now where a colleague of mine has a niece trying to make a claim to her uncle's assets. They were married for 60 years and he had bonds or something in his own name. But the niece is trying to get a piece of it because, people are greedy. So no, community property states doesn't fix it. If you have it in joint ownership, that will protect on the death of the first spouse because the survivor wins in that case. But then what happens when the survivor dies? So you've kind of got a problem there. I am now the designated POA for power of attorney for my 88-year-old mom who has dementia. Dad passed away. Is there a process where I can designate a backup person to help me with the POA for asset management? Okay, so no, unless the power of attorney specifies. Your mom defined who will act, and you can't name somebody else on her behalf. Some powers of attorney allow for you to hire agents to act for you. So certain places may accept another person helping. But as for naming a successor to you, no, they can't do that. Okay. I have a general power of attorney with all the powers checked off. Do I still need a durable power of attorney? I worry about our language right there. So if the general, so durable means that there's a line in there that says, this power of attorney shall not be impacted by my later incapacity, meaning that when I become incapacitated, it's still valid. I would need to look at that specific power of attorney, just make sure that language is in there. There are some powers of attorney out there that become ineffective once somebody becomes incapacitated. I know it makes no sense, but I didn't write the law. Okay, what if you spend all the money to get a conservatorship and then find out towards the end the patients decided to go into a facility and you didn't need to spend the money? That's happened often. So in this world, right, when I try to say a conservatorship is a nuclear option, before we do a conservatorship, we explore every option. And a lot of facilities have ambassadors, or I mean, they're marketing department people, but they're very good at what they do. And I'm not going to say that, you know, therapeutic fibbing is the right answer all the time, but sometimes how we talk to the patient matters more than what we're saying, right? And I'm court appointed. So let's say somebody files for conservatorship and they want to take away someone's rights. I will be appointed by the court as the person with dementia's attorney. And I, in that conservatorship, will fight for whatever the conservatee or proposed conservatee wants. So if they want to stay home, I'm going to fight for that. But a lot of times in my experience, how I ask the proposed conservatee the question is how they answer me. So if I say, do you want to stay at home? Of course they want to stay at home. If we ask, do you want to live at this facility? They may say yes. So I've had situations where we weren't sure what was going to happen. And I said, well, why don't we, you know, have lunch at the facility and go through the process there? So, you know, asking somebody if they want to get locked against their will, of course they're going to say no. But are you going to take them to a community where they can have social aspects, they can have music programs, they can have an enjoyable restaurant? Half the time the food is fantastic. So a lot of times it's how you approach it, how you bring it up. Don't go nuclear before you try every other option first, because that's the problem. If you started the conservatorship before you tried the alternatives, you wasted all the money. Is total out-of-pocket monthly payment for boarding care tax deductible? I am not a CPA, so I will not answer that. I will say that there are medical deductions for it, so I don't know the answer, because there is a difference between independent care that you're receiving and assisted. So I would say you have to ask a qualified CPA. Can I, as my dad's daughter, be part of the caregiver support program? He is a veteran in memory care. You can work with them to get the support. Yes, I don't quite know what you mean about being part of the program. You would reach out and see, because they do have caregiver support programs as well. So you definitely want to look into that. Is it still true that Medi-Cal will not pay anything towards memory care facilities? And what happens to the patient when the caregiver runs out of money to pay in the memory care? There are some memory care that accept Medi-Cal. There is programs through the Community Health Group program of Medi-Cal, which is like an HMO under Medi-Cal. There are the 3 facilities: Heritage Hills, Bayshire, Carlsbad, Cloisters, Vista del Lago. This was 4. I know that they do and have memory care. There are assisted living waiver program options as well that are memory care based. So there are a few, it's just limited. Let's see, I'm a veteran and my spouse has Alzheimer's. Am I entitled to any help from the VA to take care of her? If you are financially eligible, then yes, there is a benefit for a spouse. It is the base pension of non-service connected pension benefit. So you don't get the high VA aid and attendance, which is I think $2,400 a month approximately this year. You would get more like $1,600 a month, maybe $1,500 a month. Yes, so it is an available option if you're financially eligible and service eligible. Let's see, if we have a combined income of $8,000 per month, a car, house, over $3,000 savings, and paying long-term care insurance plus assets in a trust, are we qualified for Medi-Cal? The $8,000 a month is going to be your problem right there, because you are asset over by too much when it comes to the CSRA currently, because it's $2,000 for the sick spouse, 100 and what did I say? I can't remember the number off the top of my head. Oh goodness, and 130,733, something like that. In July, you would only be about $30,000 over resource, but your $8,000 a month in income will pretty much make somebody ineligible depending on whose money it is. So it's the name on the check rule. If the sick spouse is the high income earner, then most likely Medi-Cal is not an option. If the sick spouse is the non-high income, then it may be eligible. So we would just have to kind of run the numbers. If a POA is legally unable to make a decision to place their person in a memory care, what types of decisions can they make? So a power of attorney for healthcare can make every other medical decision but placement in a memory care. They can't sign the agreement. You can't sign somebody against your will. But again, as in practicality, I know that all facilities allow them to do it. So let's see, what happens if the sole designated power of attorney passes away? Who takes over? That's the problem. If you don't have a backup under the power of attorney, that's when you have to have a conservatorship. So we have a case right now where a niece is coming in because the daughter passed away for dad. And so a niece is coming in and we have to do a conservatorship. There's just no other option. And if there's no family member, then you're in with the county. Is there a look back on cash and such as investments that the VA will look at? So yes, for veterans, we can no longer do gifting if we want to apply within 3 years. There is still an option to transfer a home because it's not an asset. So that's what I say. If there is some, if you have a home and we're doing it, there's some planning that can be done because the house is not defined as an asset under VA currently. Okay, and now that's everything on that I see on the question and answer. I was trying to go through is 11:49. And I'm looking at the chat. Bear with me.
I have been letting people know in our chat. It looks like I don't believe we got too many questions in the chat, but I am letting people know how to reach us so that if there are follow-up questions, we can either connect them with the right resource, connect them with an attorney in our community. So even if someone didn't get their question answered right away, we'll definitely be able to find a way to get their question answered for them.
Let's see. And can you have a successor power of attorney? Yes, in your power of attorney, you can have as many names as you want. I like to name 3. That's my standard because I feel like, you know, the likelihood of needing to hit your successors is already low. So if I can make 3, then I'm good. And I think that's it. Did I go over time?
Right on time.
Okay. Let's see. And I think, is Amy going to come on for the next steps? So for the next steps, what I recommend, I want you to gather important documents. You need to look at your income. You need to look at the assets, property, investment, saving, insurance policies. Gathering everything is half the battle. Putting it all in one place, seeing what you have. I'm always surprised how people they forget about certain things. Putting it all together is very important so that if there is a crisis, somebody can find it. That's what I say. Wherever your estate plan is, you want to make sure that you've put in recent documents. And end of the year is the perfect time, or beginning of the year is the perfect time because everything sends you an end of year statement. You get your new Social Security benefit statement. You're going to start getting your 1099s. This is the time to compile it. So you only have to do it once a year, right? One time, one and done. Keep copies of legal documents in one location, please. I can't tell you how many times somebody has come in with their estate binder and they're missing one of the powers of attorney. I'm thinking, where did they do it? They took it out, they forgot, they gave it to the bank, then they put it away, they didn't put it away. Please make sure you put it together. Tell a trusted family member or a friend where they are located. I have some clients who don't really trust people very easily, but they trust me. And so we have in their file where it's located, right? And I have one lady, she's so adorable. She's got my card and she wrote on it, "Call Kim when I die." And she put it on her fridge. And I just thought that, she didn't want people having access. She's, and I appreciate that. I'm a control freak. So I appreciated that she didn't want people having access. But that's what she did. And that was her way. So we have it. Somebody needs to have it. We don't keep originals in our office. I don't like that. I don't want that liability, but we at least will keep a copy of everything. And you want to create and update those essential planning documents. If you don't have any, at least get powers of attorney, please. I mean, I highly recommend a qualified elder law attorney. I always will. If that's not an option for you, there are advanced healthcare directives. I know Scripps has a great one on their website. I really like Kaiser's. I don't like them for much, but I really like their advanced healthcare directive. All those are free. Talk to your doctor. See if your doctor's medical group has one. Get that for free. I know that Office Depot has at least a basic durable power of attorney for asset management. I will tell you that that is only good enough to give somebody access to things. If they need to do any type of future planning, it's not good enough. For instance, I have a situation where they're in a crisis and they only have the form, and we can't create a trust, and now we're going to have a conservatorship and a probate out of it, and it's quite a bit of a nightmare. But at least the gentleman who's acting can at least access the bank accounts right now, so there was a positive. But there'll be a conservatorship for the husband because he didn't have a power of attorney. We want to discuss the contents of the advanced directives with the named agents. You love your loved ones. You know, you've spent your life protecting your children. You, as the caregiving child, are going to have to live with what the decision you make is. Have the conversation now. Have it. I can speak from personal experience. I can speak on behalf of all the clients that have gone through it. Knowing somebody's wishes made all the difference. It's hard to be the decision maker, and love your loved one enough to tell them what you want so they don't have to carry the guilt. And you know what, push your loved one enough to make them tell you what they want. Please, that's a fact. I can't tell you how emotionally you need it. And then find out what specific institutions need to have on file. You know, we just talked about Fidelity having something specific. I know that there are other banks that want their own forms, and when it's too late, it's too late. So if you've got assets somewhere, call them, go online. They may have a little tab online, you know, click on it. What do I need for an agent to act? It doesn't hurt to have more of them filled out. Trust me, you be over prepared, not under. Okay, legal and financial planning outside of California. So as I said, California, we're kind of an island to ourselves. We do things differently here. We have planning options that they don't have anywhere else. And lawyers are licensed in individual states. So I have clients that will do planning for here in California that now can no longer move to Virginia to be with the other child. We have to plan things appropriately. It's just important. So if one of your plans are I'm going to move to Texas, or, you know, my long-term plan is I'm going to take care of my loved one here for a while, and then they're going to move to another child in Michigan. Make sure that the planning is done for both states, and make sure you seek counsel from an attorney licensed in that state and where the assets are held, because Medicaid eligibility requirements are very different. We have very, very broad ones here. In fact, we're the only state that's going to have this $130,000. I'm assuming other states are going to follow suit soon, but we are the only state that has it. And so whenever you're thinking of long-term, think of all of the options, because we did have a problem with somebody who did planning in California and then wanted to move to Virginia. I said we had to unwind all that planning so they could leave the state, because in their new state, they wouldn't have been qualified. So it was important. So make sure you do advanced planning. There are so many resources. So your advanced healthcare directive, there you go. Here's a website, click on it, get one done. The POLST, the Physicians for Life Sustaining Treatment, that is a really good option to always have when you are in that stage. If you are healthy and 50, you don't need it. Don't let your doctor talk you into it, please. I had a client who had one, and I'm like, what, are you sick? And he's like, no. I'm like, why do you have one? You know, your life is going to change a lot between now and when you need it. So make sure it's appropriate for you. I love the Consumer's Toolkit for Healthcare Advanced Planning. You know, it's free. Again, look at these free options. They're good for discussion purposes too. And then Compassion and Choices, Dementia Provisions for Advanced Directives. One of the things we like to talk to with our clients is if you get advanced dementia, severe advanced dementia, where you don't have a quality of life, right? We're not talking about that I forget things and I forget people's names. We're talking about nothing brings you joy stage of an advanced dementia. Talk to your loved one about, what if you get pneumonia or a staph infection or something that is treatable, very treatable with antibiotics? Do you want those antibiotics if you are in a stage of your dementia where you will never improve and you have no quality of life? That is a very hard question for your loved one to answer. Should I withhold treatment? Should I withhold something that's very easy to do? That is a very hard answer to give. So those are the types of things you want to discuss. Now, when looking for an elder law attorney, NALA, National Academy of Elder Law Attorneys, is probably your best resource. It's a higher level, meaning that since there's not like a magic book that we can look in, they provide a lot of education services to lawyers. So when you're a member of that, generally you have a very good working knowledge of the issues related to elder law, which are long-term care, Medicaid, Medi-Cal, VA. National Elder Law Foundation, that's NELF. They are the organization that certifies specialists in elder law. So again, there's 4 elder law attorneys in San Diego County. Only 2 of them are actually doing this work anymore, me and Phil. He's on the list. So, but there's a lot of NALA attorneys that just don't have their certifications. Doesn't mean they still don't know what they're doing. It's just NELF does provide a specialist for, and that's what we are. The State Bar of California, always a good place to look, see if the attorney may be disciplined. Very important. San Diego County Bar Association, that's going to help you find somebody local. CANR, California Advocates for Nursing Home Reform. I refer people to CANR more than probably most attorneys, but because I get the hard questions. And CANR is really out there for the consumer to really help you access benefits. And if you're having trouble and there's just don't know where to go, so always look towards them. They've got a website that's very hard to navigate, in my opinion, but has the best information. Since California is an island to itself, CANR, so going back to that slide, the canr.org has the only true California specific laws. So everything that I've talked about today, all the details, all the numbers, all of that is on canr.org. So, and they have a hotline you can always call. Oh, where'd I go? Sometimes it moves, sometimes it doesn't. I may be skipping a page. Oh, come on. I really want to stay on this page, I guess. Okay, resources, regulatory agencies. So when you're looking at placement, look at any type of complaints and things like that. You can go to the Department of Social Services Home Care Services Bureau. You can do the Community Care Licensing Division, Department of Public Health. You can look to see if care companies have complaints, if there's any violations, anything like that. You're going to want to look to make sure, I mean, this is your loved one. They're going to have unfettered access and probably very little oversight. So you really want to kind of do your homework on them. I don't know why this isn't moving. Sorry. So benefits. So we've got Medicare.gov, right? That's your basic. You can go look on the government's website. One of my favorite resources that I utilize as the attorney, and otherwise that's how I learned how to do some of the stuff I do. The general public can go to it. The Center for Medicare Advocacy. I had a client come in and needed help with his wife who was going to be patient dumped, meaning that the facility was trying to dump her illegally, get rid of her. And I didn't know what to do. I'd never done it before. I called MedicareAdvocacy.org. They walked me through it. Now I teach other lawyers how to do it, but you can do it. They are a great resource for you. Social Security Administration, I know it's a government agency, but they answer their phone. You can also check out the compassionate allowances. So that website's there. Medi-Cal's website's there. Also the caregiver support program from VA. So you're going to want to look at these. And there you go. That's my portion of the presentation. And I'm
Thank you so much. Anything you would like to say in in closing about your practice or how people can reach you before we wrap up here?
Well, I mean, my numbers there, I love what I do. I hope that comes across. I know what you are going through and I know how hard it is. Um, it's something that if I can help, we would like to at our office. We also, if we can't help, we would like to help you find somebody who can. So we do the estate planning, the long-term care planning, the special needs planning. We try to avoid the crisis, but we do also handle the crisis planning as well as what happens after passing. If we do our job right, that won't happen. But since not everybody had access or it might be too late, we can help through all the processes. But if you need anything, I have great staff here that, even if you don't think I'm the person, if maybe I have a referral, we have a referral list and somebody in my staff might be able to help you as well.
Great. Thank you so much for that offer of assistance and just generally for being such a tremendous resource to us. I learned so much from this program every time, but in particular, there's a lot of important changes ahead. So thank you again for being here for all of us. Alzheimer's San Diego is here for anyone. If you're not familiar with us, we're a local nonprofit organization. All of our programs, services, supports that we offer to people living with dementia or people who are caring for or care about someone who's living with dementia, it's all free. And it's available to anyone who needs it. So in the name of time, I won't run through our programs and services in detail, but Mina has put information out in the chat. She will put, she put a link out in the chat where you can follow up with us, fill out that form. Let us know what you're looking for. If you need more information, if you need the list that Ms. McGhee referred to a few times regarding the list of local estate planning and elder law attorneys. If there's other resources you need to learn more about, you can find a lot of information on our website. You can call us or you can fill that form out and a member of our clinical services team will just reach right out to you directly and get you what you need. So hopefully no barriers to getting the help and the support and the information that you need here. So just a couple of upcoming programs we want to make sure you're aware of. We will be doing a program next week in partnership with Elder Help on the topic of coping with personality and behavior changes. This is a program for care partners. And the following week, we will be holding one of our drop-in education hours. We do these on a regular basis. It's just a 1 hour unstructured program. The members of the education team, we're just there to answer questions, hear what you need and connect you with information, resources, support as best we can. So no program, no agenda, just bring your questions. And then early February, we will be doing our core education program on the topic of Dementia 101, sort of learning the ins and outs of Alzheimer's disease and the other types of dementia, the symptoms, the risk factors, and what to do if you're concerned or if you have recently received a diagnosis. So that's it for today. We will end the webinar shortly here. We would really appreciate your feedback on this program. If the content was helpful, if there's anything you felt was missing, or if there are other topics that you'd like to see us cover here in the education program here at Alzheimer's San Diego, we'd love your feedback. It's anonymous and it only takes a few minutes. So when the webinar closes, you'll be directed to that. We'd really appreciate the feedback. We will be emailing out a copy of all of these slides. So all those resources that Ms. McGhee went through there at the end of the program, we will make sure that you have all those names and links, as well as all the detailed information that was covered, as well as a link to our webinar library where a recording of this program will be archived and available within a couple of days. So with that, I will wrap things up. I thank you again. Our deep thanks to Kimberly McGhee for the great information and all the support you provide to us at Alzheimer's San Diego. My thanks to Mina she was very busy today in the Q&A and in the chat. I really appreciate that. And our thanks to Cora for being here to support everybody with all the tricky tech stuff. So have a great afternoon and thanks very much.